Hi guys, and welcome to another episode of Atty. Vlogger, Law for the Everyday Layman. Today we continue with part 2 on the law of partnerships, and we'll be talking about the different classifications of partnerships as well as the different kinds of partners. So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now, a like on this video would be greatly appreciated. Okay? So, let's begin. No? We begin with the classification of partnerships. Now, there are different classifications. No? We can classify partnerships according to object, according to liability of partners, etc. Okay? So, let's begin with the classification of partnerships as to the object. Now, a partnership may either be a universal partnership as to the object or a particular partnership. Okay? And when we talk about universal partnerships, these are partnerships which expressly or impliedly encompass either all the present properties of the partners or just all of the profits. Okay? So, that said, no, there are two kinds of universal partnerships. No? The universal partnership of all present property or the universal partnership of profits. Okay? But before we go into those two kinds, no, I first want to mention that there are certain prohibitions on the persons who may enter into a universal partnership. Okay? So, the law says, no, that persons who are prohibited from giving each other any donation or advantage, they cannot enter into a universal partnership. Why? Because to allow them to form a universal partnership would be permitting them to indirectly do what the law expressly prohibits. In other words, no, the law prohibits these people from giving donations or advantage to each other. If they enter into a universal partnership, they might use that partnership as a means to be able to give themselves or each other rather donations or other advantages. No, they will be circumventing the prohibition set by law. Okay? So, in that case, no, if a universal partnership is entered into by those persons who are prohibited, no, then the partnership will be void. Okay? It's void because it is contrary to law. Now, who are these people who are prohibited from giving donations to each other and therefore prohibited from creating a universal partnership, no? First, we have legally married spouses, no? They cannot enter into a universal partnership, but take note, they can enter into a particular partnership or a limited partnership, such as for the exercise of a profession. Okay? The second class of persons who are prohibited from giving donations and therefore prohibited from forming a universal partnership would be common law spouses or those who are spouses without the benefit of marriage. Next would be persons who are guilty of adultery or concubinage. Now take note, a prior conviction is not necessary. It simply suffices that they are guilty of adultery or concubinage. And finally, a person and a public officer or the wife of that public officer or the descendants or ascendants of that public officer, they are prohibited from entering into a partnership by reason of the office of that public officer. Okay? Now, we can go on to the two kinds of universal partnerships, no? First, we have the universal partnership of all present property. Okay? In this kind of partnership, the partners contribute all of the property which actually belong to them into a common fund. Okay? And with the intention of dividing the same among themselves, as well as all of the profits which they may acquire through those properties which are contributed. So in other words, the following become common property of all the partners. First, property which belong to each of the partners at the time of the creation of the partnership. And second, all profits which they may acquire from the property contributed. Okay? So what about profit from other sources, no? May they be included? As a general rule, no. Okay? But they may be included by stipulation of the parties. In other words, the parties have to agree. However, take note that future properties, those to be acquired subsequent to the creation of the partnership, future properties cannot be included in the stipulation or in the creation of this universal partnership. Okay? Why? Because to create a partnership, the things which are contributed, they must be determinate, no? And if it's future, if they are future things, they are not determinate. So therefore, future things cannot be contributed. Okay, so generally, if a party or a partner acquires property subsequent to the creation of the partnership through inheritance, legacy, or donation, the property itself is not included. However, they may stipulate that the fruits of those properties subsequently acquired may be included for common enjoyment. Okay? So that's the universal partnership of all present property. Okay? We can now move on to the universal partnership of profits. And what is this, no? It is simply a partnership that comprises all that the partners may acquire by their industry or work during the existence of the partnership, as well as the usufruct of movable or immovable property which each of the partners may possess or own at the time they enter into the contract of partnership. So unlike the partnership of all present property, here in the universal partnership of profits, movable or immovable property of each of the partners continues to pertain to each of them, It does not pertain to the partnership, What the partners may gain over that property, if any, is merely the usufruct or use of those properties. In other words, the partners, they retain the ownership over their present and future property. What passes to the partnership is merely the profits or income and the usufruct or use of the property they own. Okay? So on dissolution of the partnership, the property will now be returned to the respective partners who own them. And of course, the profits which are acquired through chance, such as through lottery, or those acquired without any physical or intellectual effort, they are not included. Okay? So just remember that profits which the partners may acquire by their industry or work and the usufruct over the properties during the existence of the partnership, they belong to the partnership as a matter of right. In order to exclude them from the partnership, a stipulation is necessary. Okay? But what about the fruits of the property which are subsequently acquired? They do not belong to the partnership, but they may be included by stipulation. Okay? So now, what if there are several persons who want to create a universal partnership? However, in the articles, they fail to specify whether it's a universal partnership of all present property or a universal partnership of profits, What does the law say? The law will consider that kind of partnership to be a universal partnership of profits. Okay? Why a universal partnership of profits? Why? Because it imposes less obligations on the partners since they preserve their ownership over their separate property. This is under Article 1781. Okay? Now, those are the two kinds of universal partnership. We can now move on to the second classification of partnerships according to object, specifically a particular partnership. And what is a particular partnership? It is one which has for its object determinate things, their use or fruits, or a specific undertaking, or the exercise of a profession or vocation. Okay? So, some examples would be a partnership that is formed for the purpose of acquiring a piece of land in order to resell it at a profit, or for the common enjoyment for its use and the benefit of the partners. Or a partnership may be created to carry out a specific enterprise, like to construct a building. Okay? And a partnership may also be created to practice a certain profession. Okay? In which case, it will be known as a professional partnership. So, a law or accountancy firm is a particular partnership, specifically a general professional partnership. Now, take note of the difference. One of the biggest implications would be in the realm of tax, no? Because an ordinary partnership will be taxed on its income, and each individual partner will also be taxed on their respective individual incomes, no? But in case of a general professional partnership, only the partners will be taxed, and the general professional partnership will not be subject to tax on its income as such partnership. Okay? So, that's it for the classification as to object. Let's move on to the classification of partnerships as to the liability of partners. First, we have the general partnership, okay? In which case, all the partners are liable pro rata, okay? Proportionately beyond the partnership assets for all the contracts which may have been entered into on behalf of the partnership or in the partnership's name, under the signature of the under its signature and by a person who is authorized to act for the partnership. Okay, so here the general partners, they are liable even with their properties for the partnership liabilities. Okay, and then we have the other kind. We have the limited partnership. And what is this? In a limited partnership, there is one or more general partners whose liability is unlimited. Okay, and we also have one or more limited partners. Okay, and their liability is such that they are only liable for the partnership debt, okay, only to the extent of their stipulated contributions. And where is this stipulated? It's stipulated in the Articles of Partnership. And the partnership itself, the name of the partnership, must contain the word limited. Okay? Next kind of classification, we have the partnerships as to duration. Okay? First, we have the partnership at will. A partnership at will, no? It has no fixed term or there is no particular undertaking specified for the life of the partnership. In other words, the birth and the life of the partnership depends on the mutual desire and consent of the partners. In other words, any one of them may, at his sole pleasure, dissolve the partnership at his will, but provided it should be done in good faith. The dissolution must be done in good faith. Okay? But what if it's dissolved? What if the partnership is dissolved in bad faith? Will that prevent dissolution? No. Okay? In that case, the partner who dissolves the firm in bad faith will only be liable for damages. Okay? So the second kind is the partnership with a fixed term or for a particular undertaking. Okay? And this is a partnership which is entered into for a definite period. Okay? It's fixed. That definite period is fixed by the express agreement or necessarily resulting from the nature of the particular undertaking. Okay, so if the particular undertaking is to build a certain building, of course that will not go on forever, and when the building is finished, when the construction of the building is completed, then of course the partnership will end at that time. Okay, so this term, this fixed term, or this particular undertaking should be specified in the Articles of the Partnership. Now, what if the business of the partnership is continued after the term has expired or after the undertaking has been completed? What is the effect now? then the partnership will now be considered to be a partnership at will. Okay? So we follow the rules on partnership at will if they continue it after the fixed term or the completion of the specified undertaking. Okay? Now we have classifications of partnership as to legality of existence. No, and this is very quick. No, we have the de jure partnership. No, which is a partnership that has complied with all the legal requirements, and we also have the de facto partnership, which simply put has not complied with all of the legal requirements to create a partnership. The next classification would be classification as to how the partnership represents itself to others, no, to third persons. So first, we have the ordinary or real partnership. Na it's an existing partnership and it represents itself as such. We have no problem with that. That's the normal, ordinary kind of partnership, no? What we have to talk about is the ostensible or the partnership by estoppel, the ostensible partnership or the partnership by estoppel. And let's just review what is estoppel, no? Estoppel, no, or estoppel, depends on how you pronounce it, no? Estoppel is a bar which precludes a person from denying or asserting anything contrary to that which has been established as the truth by his own deed, his acts, or by his representation, whether it is expressed or implied. Through estoppel, no, an admission or representation, okay, is rendered conclusive upon the person who made it, and he cannot deny or disprove it against the person who has relied on such representation. Okay? So here, in a partnership by estoppel, a person who is not a partner may become or may be treated as a partner because of this concept of estoppel, no? And if he is treated as a partner, this is for the purpose to hold him liable to innocent third persons as if he was a partner. Okay, so this is really for the protection of third persons. Okay, and how do we know? How do we treat him as a partner? When will we apply this? No. So, this person will be treated as a partner when by his words or his conduct, he either one, he directly represents himself to anyone as a partner in an existing or non-existing partnership. No, so let's say I say, hey, I'm a partner of the XYZ partnership. Okay, I'm a partner of this. I'm representing myself to be a partner of this certain partnership when in fact I am not. Okay? Or it can be XYZ are just people who are not in a partnership. I say, oh, these guys are partners and I am also partners with them. That's the first scenario. Okay? There will also be a partnership by estoppel in case a person indirectly represents himself by consenting to another person who represents himself as a partner in an existing or non-existing partnership. So for instance, no, X comes to me and says, hey, I'll tell Y that I am partners with you, okay? And I say yes, then I am consenting, no? Now, it may so happen that I have an actual partner and there's an existing partnership. Okay, in that case, if I consent, then there will be a partnership by estoppel for the protection of Y who might be defrauded. Okay? And it will also apply even if I really do not have a partnership and I consent to X's representation that he is partners with me. Okay? So the third person who is injured, no, the innocent third person with whom that alleged partner contracted, must show or must prove that the purported partner represented himself or permitted others to represent him as a partner, and he dealt with the partnership to his injury by relying on the representation. Okay? So now, let's take up the scenarios, no? If all the actual partners, no, in the existing partnership consented to the representation, no, they allowed that person to say that he is a partner even though he is not, then it will now become a partnership liability. Okay, the partnership is liable for the transaction entered into. Okay, now what if that case earlier, that's a partnership by estoppel, no, there's no question. Now what if there is no existing partnership and all of those represented as partners consented to the representation, or not all of the partners in an existing partnership consented to the representation? Okay, what will happen now? Then only those who made or consented to the representation will be liable. And what's the nature of their liability? They will only be jointly liable. Only those who have consented or have made representations will be liable, and their liability will be joint. Finally, what if there is no existing partnership and not all but only some of those represented as partners consented to the representation, or none of the partners in an existing partnership consented to the representation? What's the liability? It's not the liability of the partnership, okay? The person who will definitely be liable is the person making the false representation, who misrepresented himself to be a partner. And if there is anyone else, even if he's just one person, who consented to that misrepresentation, he will also be liable. The partnership and those who did not consent cannot be held liable. Okay? So don't worry, no, we'll discuss this more when we get to the topic. No, I'll be giving more concrete examples. Okay? So we'll talk about the obligations of the partners with regard to third persons, and we'll be talking about this partnership by estoppel more. Just take note that in a partnership by estoppel, a true partnership is not created, Okay? It's not created between the alleged partners. In order to create a true partnership, a contract is still necessary. Okay? It is a contractual creation. It is just that in a partnership by estoppel, the law will consider the persons who represented themselves to be partners as part of a partnership only for the purpose of holding them liable for obligations entered into through their representations, no? In order to protect the rights of third persons who may have given credit to the partnership because they relied on those false representations. Okay? Now, finally, no, the last classification of partnerships, they would be as to purpose. No, this is very quick. No, in commercial or trading partnerships, then these are partnerships made for the transaction of business. And we have professional or non-trading partnerships. These are made for the practice of a profession. Okay? So now we can go to the kinds of partners. First, we have the partners as to nature or of their contribution. Okay? We have first the capitalist partner. And he is the partner who contributes either money or property. Okay, and the law says that he cannot engage in any business which is of the same nature as the business of the partnership. Why? Because there is a conflict of interest. Okay? If we have the capital partner, we also have the industrial partner, and he is one who only contributes his industry or personal service. And this industrial partner cannot engage in any kind of business for himself unless the partnership expressly permits him to do so. Okay? Why? Because he has to devote his full time to the partnership. Okay? He is not liable for the losses of the partnership. But please take note, while he is not liable for the losses of the partnership, a third person can still hold that industrial partner liable. He can ask the industrial partner to pay. And the industrial partner's remedy is simply to go after his co-partners, his capitalist partners, to recover what he may have paid, because again, the industrial partner will not be liable for his losses. Okay, don't worry. Again, we'll discuss this more in the coming episodes. Okay? Now, the next kind of partners would be partners according to their liability. And first, we have the general partner. Simply put, his liability, the liability of a general partner to third persons extends even up to his own separate property. While we have the limited partner whose liability to third persons is only limited to his capital contribution. Okay? The next kind of partner would be a partner according to management. We have the managing partner who, as the name suggests, manages the business or the affairs of the partnership. We also have the silent partner who does not take an active part in the business, whether or not he is known to be a partner. And finally, we have the liquidating partner who takes charge of the winding up of the partnership upon its dissolution. Next, we have the kinds of partners according to their exposure to public perception. Okay, we have the ostensible or apparent partner, and he is the partner who takes an active part in the business, and he is known to the public to be a partner in the business. Okay, we also have the secret or dormant partner who may take an active part in the business in case of a secret partner, but he is not known by the public to be a partner, either because he's not held out to be a partner or he's not represented as a partner by the other co-partners. Okay? And in case of the dormant partner, he does not take an active part in the business, and he is not known as or is not held out to be a partner of the partnership. The next kind of partners would be as to their membership. Okay? A real partner is simply one who is really a contributing member of the existing partnership. Okay? But we also have a partner by estoppel or a quasi partner. And we discussed this in passing in the partnership by estoppel. A partner by estoppel is not really a partner, but he has represented or he is being represented to be a partner by the other partners or by people who are not actually partners, no? So just think of it easily as someone who is pretending to be a partner, or people have pretended that he is a partner, okay? And the partner by estoppel is held liable as if he were a partner to protect the innocent third persons who may suffer injury. Okay? The next kind of partners would be those according to the continuation of the business affairs after dissolution. Okay? First, we have the continuing partner, and he is simply one, as the name implies, who continues the partnership business after the partnership has been dissolved by reason of admission of a new partner, by retirement, death, or expulsion of one of the existing partners. Okay? And if we have the continuing, we also have the discontinuing partner, and he is simply one who does not participate in the partnership business after dissolution. Okay? The next kind of partners would be classified according to the value of their contribution, no? There is the majority partner whose contribution represents the majority of the controlling interest, while the nominal partner, his contribution represents only the minority interest. Okay? The next kind of partner would be classified according to the nature of membership. First, we have the original partner who is a member of the partnership from the time of the commencement of the partnership as a juridical person. And we also have the incoming partner who becomes a member of the partnership subsequent or after the establishment of the firm or the partnership, okay? Or he can be one who is about to be admitted into the partnership with the consent of all of the members, okay? The next kind of partners would be as to the state of survivorship, no? A surviving partner remains alive after one of the partners has died, or he is one who continues to be in the partnership after its dissolution by reason of death of one of the partners. Okay? And of course, we have the deceased partner who died while he was a member of the partnership. Okay, next kind of partners would be as to the effect of expulsion, no? Of course, an expelled partner has been expelled by one of the other partner or the partners for a valid cause, while an expelling partner is the one who caused the expulsion of a partner, likewise for a valid cause. And finally, we have what is known as a sub-partner. Okay, a sub-partner is one who is not a member of the partnership. Okay, he simply contracts with one of the partners with reference to that partner's share in the profits of the partnership. Okay, he is not a member of the partnership. He just has an arrangement with one of those partners to divide whatever profits that that partner may get from his partnership. In other words, it's a partnership within a partnership. Okay, the sub-partner does not acquire the rights of the partner, and he is not liable for the debts of the partnership. Okay, in other words, there is a partner in a partnership. Okay, this is the partnership and these are the partners. No, this is the sub-partner. He has an arrangement with this guy to divide whatever profits he may receive from this partnership. Okay, so that's it for the classification of partnerships as well as the different kinds of partners. Okay, and next video we'll be talking about the obligations of the partners. No, so I hope you may have picked up a thing or two, and I hope to see you next time, guys. Okay, see you soon. Bye.